During settlement discussions with the judge asked me for my bottom line number and promised not to reveal and divulge that information to the defense. You want to learn what got me so outraged and so upset shortly after this occurred? Come join me as I share with you this outrageous story. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law in the state of New York. Now, this is a medical malpractice case that I was negotiating. The case was coming up for trial, and the judge brought all the parties in together shortly before trial to try and get settlement negotiations going. And in a private discussion with me, he said to me, Mr. Oginski, what is your bottom line number in this case? Now, I had a high demand on this case, which was a significant medical malpractice case. And I told the judge in confidence what my bottom line number was. I trusted the judge. I'd been in front of him before, and he'd always done right before. Now, he brings in the defense attorney to come in and talk to them. And the first thing out of the judge's mouth was, Mr. Defense Attorney, Mr. Oginski has just told me that his bottom line number is this amount. Do you have that amount or not? I said, Judge, what did you just do? What did you do here? You just disclosed something you promised you wouldn't do. Now I have absolutely no negotiation leverage whatsoever. Either he settles the case right now for that amount of money, or the case is never going to be settled, all because you disclosed my bottom line number. Now, I will share with you that in these types of cases, we make a demand, and the defense will typically understand that the demand we're making is not the final number that we're going to accept, and everybody understands that. So, for example, if I make a demand of $2.5 million, the defense knows that that's not my bottom line number. Instead, that's a number that I'm reaching for. However, what is my bottom line number? What is the minimum amount that I will accept in order to settle this case on my client's behalf? Well, the defense doesn't know it. I'm the only one who knows that information. And if I disclose that information too early, then I will have lost all negotiating leverage totally in the case, and likely will not be able to settle the case. I was furious with the judge, and I said so right in front of the judge and the defense attorney. And you should have seen the look on this defense attorney's face. He couldn't believe that the judge disclosed this critical information. This is privilege. This is confidential. The judge never, ever should have disclosed that information. Instead, he should have obtained from the defense what their best offer was, and now come back to me with that, and then I can come down off my demand. That's proper negotiation. That's how cases get settled. Not when you turn around and promise not to divulge information and tell the defense attorney in the very first sentence what my bottom line number is. So why do I share this great information with you? I share it with you to give you an insight and an understanding to what goes on in the negotiation process in a medical malpractice case or an accident case or even a wrongful death case here in New York. You know, I realize you're watching this because you likely have questions or concerns about your own particular matter. Well, if your matter happened here in New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a great day.